Even though they may not reside there, the tribe will still have jurisdiction in that instance.
All right, talking about some common questions about special domestic violence jurisdiction. Whether or not its implementation is mandatory and therefore an unfunded mandate. No, there is no requirement that any particular tribe or any specific number of tribes even do it. It's entirely voluntary. The tribe has to go through quite a process to get there, and it can be expensive, like Troy mentioned, having to get jails up to a different code to be able to house people for longer than the 1 year that they can. So it does cost a lot of money, and so it's not an unfunded mandate because the tribe has full free choice as to whether or not they want to try and seek this. The second question is, does SDVCJ change or alter federal or state jurisdictions over a non-Indian defendant? And the answer to that is that by a participating tribe, it shall be concurrent with the jurisdiction of the United States in the state or both. And so it didn't modify the Major Crimes Act or the Indian Country Crimes Act, otherwise known as the General Crimes Act. What it did was it expanded under certain circumstances for certain tribes the concurrent jurisdiction under appropriate crimes and when the tribes qualified. In line with what Troy was talking about the expanding the Civil Rights Act, having the right of habeas corpus, meaning that if a person receives a jail sentence under this statute, that the court of the United States can actually review that, and that means that it's in federal court, and they can stay the detention of that person if the following things are met, which are listed here. And it shall be granted, which means it's mandatory if the court finds that there's a substantial likelihood that habeas petition will be granted, or like anytime anybody's dealing with release in the federal system, it's going to be looking at whether or not there can be conditions imposed by the court that ensure public safety and ensure that the person won't flee. And under those circumstances, then a stay should be granted. And then the other point is that when a person is being prosecuted under jurisdiction under this statute, that the person has to be advised of their rights throughout the process, and that includes that after they receive a sentence by the tribal court, that they be advised of their habeas corpus rights. This is DOJ's Tribal Justice and Safety website. It is a fantastic resource if you have any questions about the implementation of VAWA and how it can be achieved, or if you have a client that's being potentially prosecuted under this, then this would be a good resource for you. We're happy to answer questions if we can.
Real quickly, too, I'd like to add, one of the big purposes for today was just to make you aware of this. Some of you may be getting phone calls and your gut reaction is going to be, no, the tribal court doesn't have criminal jurisdiction over you. You don't have to pay attention to that. Well, it's out there. Sisseton's doing it. Standing Rock feels they're about 6 months away. They're revising their codes right now, so that's 2 Northern Division tribes already that are exercising this jurisdiction. I know we've received inquiries regarding this from other areas. If you have questions, you can reach out to me. That's fine. I'm not going to answer them for you, but I can point you in the right direction. And certainly, I would encourage you to look in the Ninth Circuit. There have been tribes in Arizona and Washington that have been exercising this jurisdiction for the last year and a half. So the roadmap is there. The sort of start of the legal challenges have already been made, and they're starting to wind their way through. So we'll be seeing some case law and guidance coming out in this area shortly. Any questions?
I was looking at the rights to a defendant in tribal court in the expanded jurisdiction case. One of the things that's listed on there is a jury with a fair cross-section of community that doesn't systematically exclude any distinctive group, including non-Indians. I'm curious, how does the tribe put together a jury pool with those criteria?
They reach out to the tribes that have already done it in the Ninth Circuit, which is what Sisseton has done. I actually was trying to find out where they got their cross-section and where they took their lists from. I haven't received a response back from them. My understanding is that they were looking at voting records and driver's license records. I mean, those would be the obvious places for them to start, and they just compiled a list for that. And, you know, interestingly enough, Magistrate Moreno is here. He had talked to me before we started here about how the 8th Circuit, or not the 8th Circuit, the U.S. Supreme Court today has announced they're taking cert on a case that involves civil jurisdiction and Indian country, so it'll be interesting to see, because that's going to be the only tribe's real enforcement mechanism for people who ignore those subpoenas. I'm sure I tap danced around your question, but shoot me an email and I'll let you.
The answer's on the way eventually.
Okay.
Does anyone else have any questions for Troy or Sarah? I know this is an area of the law that's new. It's new for all of us, and so you're going to need to be aware when you have a client that comes into your office, especially if they're up in the Sisseton area, so you know what to do to best advise them. So if you've got questions. If not, okay. I need to load the next presentation for Dana Hanna, so we'll take like a 5-minute break, grab a coffee, go to the restroom,